the brutal killings of Kenyans and seeking for investigations on all extrajudicial killings by officers of the national security organs. The right to life is enshrined and safeguarded under Article 26 of the Constitution of Kenya 2010. The preservation of the right is not only crucial for its enjoyment by individuals, but bears significant impact on our nation and its sovereignty. Invariably, the ramifications of disregard for and violation of the right to life not only indicates injustice and disregard of the rule of law, it equally paints a grueling picture of the state of our democracy and represents a damning indictment on our national security and the ability of our security organs to undertake their mandate. Historically, extrajudicial killings have emerged amongst the greatest threats to the right to life. To this effect, the Kenyan reality is characterized by a symbolic irony where those whose sworn duty is to preserve the right to life have proven to be the greatest threat to its enjoyment. Under the prevailing constitutional order, the people of Kenya sought to end the abuse of security organs as agents of political repression through excessive use of force and arbitrary extrajudicial killings. However, the past 2 years have proven that this relic of old continues to prevail upon Kenya. It is a matter of general consensus that this cannot go on. The investigative report aired by the BBC African Eye on 27 April 2025 has left the country in shock over the malice, impunity, and brutality with which unarmed young Kenyans were executed by officers of the national security organs for merely expressing their dissatisfaction with the government of the day. With such unnerving revelations, it's worrisome that the national security organs, especially the police, have an obscure understanding of their allegiance, which lies with the nation and the constitution, not with regimes or their leaders. As if totally oblivious of the damning report of the atrocities perpetrated during last year's Gen Z demonstrations, the National Police Service compounded their contempt for the right to life and the rule of law by orchestrating vicious attacks against the residents of Ang'ata, Barigoi, Kilgoris, who were peacefully demonstrating against threats to deprive and dispossess them of their property and deny them their right to enjoy that property. On 28th of April 2025, 6 innocent Kenyans were killed in cold blood at the hands of rogue police officers. The Law Society of Kenya strongly condemns these criminal acts and calls for immediate action to investigate, identify, and prosecute these criminal perpetrators within the police. Collectively, the foregoing occurrences and the reproach with which the relevant institutions and authorities have responded to the same are a cause of alarm for all Kenyans. For illustration, we are perturbed by the insensitive and thoughtless remarks that have been made by members of political class in addressing these crucial matters of national security and the state of constitutionalism. Our attention in this regard is drawn to the comments of the Member of Parliament for Mandera North, Mr. Bashir, while addressing Parliament, where he dismissed the killings of Kenyans and suggested that Kenyans and the world should move on. In a separate instance, the Member of Parliament for Homa Bay, Mr. Peter Kaluma, put out a statement making sparring accusations to the effect that the BBC was culpable for misinformation and should be banned from Kenya airwaves. The choir of absurdity has equally been joined by Member of Parliament for Dagoretti South, Mr. John Kiarie, who made despicable suggestions that one of Kenya's long-standing international allies had sponsored the BBC's recount of events, forming a dark part in our nation's history to advance some unqualified economic agenda. Such preposterous arguments and propaganda undermine the essence of parliamentary debate and put our country's august house in unnecessary disrepute and risk of ridicule. We remind elected representatives that the authority bestowed on them is held as a public trust and is for the benefit of the people of Kenya. Therefore, such contempt and haughtiness as we have witnessed is both shameful and undermines the obligations set out under Chapter 6 of the Constitution. We remind members of Parliament, in particular those who are members of the bar, that under Chapter 6 of the Constitution, their role is to represent the people and not to defend the oppressors. And their constitutional duty to provide oversight does not contemplate that they instead justify unconstitutional actions sanctioned and committed by those they ought to oversight. Further, we call on all our other members who are elected parliamentarians that they have a greater duty than their colleagues on account of their oath of office as advocates of the High Court of Kenya. That oath cements their immutable responsibility to uphold the rule of law, which is cradle to protecting the right to life. The Law Society of Kenya is apprehensive that if the current volatile situation within the public and the national security organs persist or is further exuberated, Kenyan sovereignty, democracy, and constitutional will be at the brink of imploding. Accordingly, it is the duty of every right-thinking citizen, especially those entrusted with the positions of power and service, to take urgent, deliberate, and objective action to end the menace of extrajudicial killings, bring its perpetrators to book, and find justice for all victims of these heinous criminal elements within our security organs.
We have taken note of a status update released by the Independent Policing Oversight Authority on the 28th of April 2025, highlighting the steps it has undertaken to address some 60 cases of police brutality that have been registered with the authority. From the face of the update, it appears that several of the cases have been or are currently undergoing investigation. Unfortunately, and for reasons not disclosed by the authority, nearly a year later, only 6 of the investigations have been completed and escalated to the Office of the Director of Public Prosecutions and/or the courts. This statistic is not only underwhelming, it is well near proof of dereliction of duty. In such times, laxity, complacency, and lack of urgency are tantamount to complicity. IPOA has overstretched the grace and patience of the Kenyan public, and we hereby put the authority on notice that they run the risk of being liable for refusal to act in accordance with their mandate. Nevertheless, we acknowledge that the resolution of these matters requires a collective approach involving all stakeholders and citizens. In the circumstances, the Law Society of Kenya appreciates that the country is in dire need of a paradigm shift, and we therefore recommend and demand as follows. 1, that the National Police Service Commission and the Independent Policing Oversight Authority escalates the investigations into the mass killings perpetrated by officers during last year's demonstrations to a priority status and works to resolve the outstanding cases, both registered and those not registered but within the public domain, within the shortest time practicable. Number 2, that the Office of the Director of Public Prosecutions instructs the Inspector General of the National Police Service to sanction and undertake immediate investigations into each of the officers captured and identified in existing images and videos, meeting disproportionate violence against members of the public and/or who are suspected of or implicated in the extrajudicial killings of innocent Kenyans. Number 3, that the National Security Council issues a directive to all investigative agencies within the territory of Kenya to avail all resources and expertise necessary to establish the full extent of historical extrajudicial killings in Kenya, identify the perpetrators and victims, and take available legal action against or in favor of them respectively. And 4, all documented reports of any investigations and inquiries that have been undertaken with respect to historical extrajudicial killings be made public, and all victims and witnesses thereof be placed under the Victims Protection Act under the Victim Protection to pave way for prosecutions of the officers involved or suspected to have been involved. We note that while constitutional and statutory protections exist to protect holders of public office from prosecution for undertaking their mandate, these protections only apply where the action reflects good, conscious, and legal fulfillment of mandate. These extrajudicial killings, the inaction in resolving and putting a stop to them, complicity in concealing their existence, and the impunity of justifying why they have been perpetrated do not fit within the actions that are protected by the law. End of the statement.